It's like, well, I mean, come on, with basketball, that's one of the most germ-spreading games there is because everyone's touching the ball. I mean, they're all putting their hands all over it. And with courts, it's like, it's just as filthy. They're passing around papers and they're just all packed in. I mean, we've seen what Discovery Court is. I mean, that is just a petri dish.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hey everybody, welcome to The Defense Never Rests. I am your host, Trisha Baxter, but for today I am handing the reins over to my partner, Oliver Brooks. Today's podcast episode is all about what it's like to actually have COVID and practice law. We talked to Dan Sherry Jr., who is a well-known plaintiff's attorney in the Philadelphia area. He was presumptively diagnosed positive with COVID and has been self-quarantined for 2 weeks. So how do you handle that, family, and practicing law all at the same time? And that's what we're going to get into today. Please also hit that subscribe button so that you are notified the next time our podcast episode airs. And we'd appreciate you giving us a rating and review. I hope you enjoy the episode.
Let's just start off. I wanted to get your take on, what it was like. You're the only person I've ever known who's presumptively had it. So what was it like?
Well, as one might expect, it's a challenge. It's a challenge because without the ability to seek redress in the court, or at least perhaps the threat of seeking redress in court, it can make cases that are already in suit more challenging to push along from a discovery perspective. And I'll sort of limit this discussion in the Pennsylvania Courts of Common Pleas, although we are involved in cases in other jurisdictions, including Tennessee. There have been courts that will make themselves available for telephonic conferences, and as a result, issues can be resolved. But, and I think this is perhaps more of an issue on your side, Oliver, there is perhaps an understandable reluctance for defendants, particularly when it comes to individual defendants or corporate representative defendants, to not have those people deposed via Zoom. Whereas this might before be something that could be accomplished via video conferencing depositions, there is, not all, but some defendants who believe that they cannot put forward the type of affirmative defense they would want or get their position across unless they have the opportunity to confer with their own counsel in person. In fact, with many corporate depositions that I've conducted via video conference over the years, it is extremely unusual that the defense lawyer will not be with the witness in the same room. Obviously, with COVID-19, that creates a profound impediment. However, by the same token, I've gotten some unusual requests. We are involved in a case right now where a young woman is a quadriplegic, and the defendants wish to depose her in person, even with the COVID-19 outbreak. We have told them this is certainly something we should conduct via video conference, but they refuse to do so. And because there's no hard order in place saying you must, it's merely recommendations and encouragement from the court, there's not really too much that one can do to probe them to move in an area that I think would be perhaps more expeditious and more safe. That's impacted, those are the impacts that I've been seeing from at least a discovery perspective and a deposition perspective. In terms of initiating cases, in Pennsylvania, there's been guidance that cases that are put into suit, even if there is not, at this point in time, the ability of a prothonotary to get back to you the proof that you filed something. If you can demonstrate that you have a receipt for filing something, that will act as a way to toll the statute of limitations, specifically writs of summons. We have seen in the past couple of weeks, the courts, however, including the Philadelphia Court of Common Pleas, actually accepting complaints. So not only do we get the receipt that the case has been filed, we actually get notification it's been accepted. However, as you can probably appreciate, Oliver, in Pennsylvania, for in-state defendants, and this is true in many other states, you have to serve the in-state defendant in person. And if you are suing an entity that is not engaged in essential services, the likelihood that there will be someone there to accept services is nil. And one would imagine if you're serving by sheriff, which you must do in most counties in Pennsylvania, even assuming someone was there who could accept service, the likelihood they're going to open the door if somebody in a uniform comes walking up is likewise nil. This has created sort of a gridlock in the form of having to constantly just reinstate complaints until such time as someone is there to accept service, whenever that might actually be. Now, again,
assuming that they open up again.
I beg your pardon?
Assuming that they ever open up again. I mean,
Assuming that they ever open up again, exactly. And one might expect a glut of services via publication or alternative services once we start to see this bottleneck open up as a result of what's been happening to COVID-19. Now, there are exceptions to that. Obviously, if the plaintiff attorney has a relationship with the defense attorney, they may send just a courtesy copy of the complaint along with the requisite language. Hey, look, I'm just sending this to you. I'm not asking you to accept service, but just be advised that this is out here. That also, I mean, but there is understandably a reticence on plaintiff's attorneys to do that, because all that is doing at that point is giving the defense more time than it otherwise would have to prepare not only affirmative substantive defenses, but also more comprehensive preliminary objections. So that's sort of the issue that we see. You have people basically wanting to keep their powder dry on both sides of the aisle. So that's sort of from a case initiation standpoint what we're seeing. I guess I'll now take the sort of the last point, and that's case resolution or case finality. One wouldn't want to get in trouble with any language. I forget, Oliver, as to what's the language that I now see in the releases. You can't say settled anymore. You can't say resolved. We'll say the ending of cases. How about just the ending of cases? The cases that are not thrown out on summary judgment or judgment on the pleadings. We are seeing an uptick actually in interest from defendants to conduct mediations via Zoom. And we have the first one. My firm has its first Zoom-based mediation coming up in 2 weeks' time. It'll be interesting to see how that works. I foresee Zoom being very, very helpful in terms of joint presentations or joint video, provided that everybody has decent internet access and you're not getting sort of the quintessential slowdowns and glitches and bleeps and blubs that can come with embedded video in a PowerPoint. Sometimes that happens, obviously, when a PowerPoint is even in a courtroom. That's usually when it's more embarrassing. But we can see that being perhaps an issue to it. The other thing that really has not been fleshed out, and even some of the more sophisticated alternative dispute resolution crews have not yet figured this out, is the issue of privacy and confirming that there is going to be private interaction between the mediator and the individual parties. When we do a traditional mediation, people are usually at the mediator's facility. They are placed in the separate rooms. And as a result, there is at least the aura that there is going to be confidentiality when the case is frankly discussed between the party and the mediator. Whenever you're introducing technology into that particular area, there always is the issue that could this get hacked? Could this get recorded? What could happen in that regard? So we're actively speaking with defense counsel right now as to how they want to handle it. For example, maybe just doing Zoom insofar as the joint presentation, and then logging off of Zoom and having the mediator initiate video chats or video telephone calls with the individual defendants. That way, there is no risk whatsoever in terms of a party inappropriately becoming privy to what one hopes to be frank discussions. Obviously, the mediators want to encourage frank discussion about a case's weakness with the individual party. If the mediator is going in and telling a party about everything that's great about their case, one doesn't really understand why the mediator is being paid. That is a profound waste of time. You want the mediator to hit you hardest to your case's weaknesses and also do the same for the other side. But that's not something you necessarily want to hear you want the other side hearing about, especially as it develops. So that's something that we're seeing. And not only are we seeing that insofar as mediations with, I'll call them relatively smaller defendants, the smaller companies, but also with international companies. We have one scheduled at the end of June with an international manufacturer. Again, that's going to be taking place via Zoom, and probably there will still be discussions about what the safeguards are with it. But it shows to me that there is still a desire to have these cases move along. And I'm sure they're case determinative and case specific in terms of what are the injuries and is the person dead. As we like to say, they don't get any deader. Or is the person at risk of imminent death? Are they immunocompromised? Is COVID-19 perhaps going to change the entire complexion of the case if somebody's immunocompromised? These are all factors for defendants to consider, but I haven't seen any type of blanket desire not to move the cases forward, at least so far in the catastrophic personal injury cases that I'm involved with.
Yeah, we have a little bit of a different situation going on. We have several cases coming up for mediation, which we're not really entirely comfortable with mediating telephonically or over Zoom or WebEx or whatever the case may be, because two main reasons. In one of them, we have a number of co-defendants, additional defendants, who don't seem to understand the extent of their liability. And we are concerned that they will simply just log off. And it needs to be a global resolution. In Pennsylvania, these joint tort fees or resolutions can be quite tricky, particularly for product manufacturers who may have products hanging out there in the universe of that particular industry. So in that case, we've tried to postpone that case. Luckily, and I say luckily, it sounds terrible, but the injured party actually died in the accident. So as you said, he's not getting any better.
Right, and that is, and I can also understand, the importance of having a presentation with people actually there. This is not anything new in terms of communication, but just as there are certain podcasters that do quite well when the people are speaking face-to-face in person, there are other individuals, radio hosts like Terry Gross, that actually will apparently not look at the other person when she's interviewing them because she doesn't want her audience to have a different experience than she's having, just wanting to hear the pure audio. I would imagine that with certain cases, there's not much of a desire to do, in essence, a dry run with the other side there in advance of trial if you have no guarantee that they're not just going to mute you or darken the screen or do any of those things while the presentation is going on. It's one thing to hang up on a person who's calling you on the telephone. It's quite another thing to slam a door in somebody's face. And part of the intrigue and perhaps rate of success with mediation is having people in that room in the moment experiencing almost that visceral reaction to having an adverse party explain why they are at risk for moving forward with a particular trial.
Yeah. That may be the first time that they've ever heard your position is not without flaws.
Certainly, and that would also depend on the timeline of the case. One would hope that once you get into the pretrial memorandum stage of the case, for those watching outside of Pennsylvania, that is after the close of discovery. It is generally after the production of expert reports. People are identifying all the witnesses they intend to call. They are setting forth their exhibit list. Oftentimes, mediation is helpful after that point in time because you have the sort of Damocles insofar as it's usually a trial date certain looming, but also you understand what the other side is about. That being said, a party may not still completely understand the risks they face or why the affirmative defense that sounds so good on paper may not fly in a courtroom, or for that matter, why a particular theory of liability advanced from the plaintiff is likely to be disregarded by a jury or thought of as not palatable or not representative of how most people interact with a product or interact with a contractor. So yeah, all of those things in terms of how will that play out in a mediation. I think it's fair to say that an in-person mediation is always going to be preferable, just like taking a deposition in person is always going to be preferable than video conference. It just is. You get a different vibe off of that witness when you're in person, passing them papers, seeing their reactions. But it is the necessity of the day and age we live in.
Yeah. And when it comes to the depositions, in most of the cases that I'm working on, I have very skilled adversaries, but I have a couple of them where you may be having people who are on both sides, plaintiff and defense, stepping outside of what they're used to doing, and they're just not that I don't want to use the term like skilled, but they're definitely outside of their element, and you can feel that. And when those sort of things happen, rules and ideas like of common courtesy can be bent a little bit.
Yeah.
Particularly I have one where there's a very real potential for punitive damages against the co-defendant. It's a closely held corporation. This person is in legit peril of losing everything. And I don't think that we can agree to do a remote deposition of that person because we don't know who else is in the room with her. I don't want this to be a teleprompter situation or cue cards being held up. Now's time to cry.
Excellent point, and one that I did not bring up. But yeah, usually you have one neutral in the room, and that's the court reporter. Well, guess what? Under COVID-19, they ain't in the room, at least not unless they're masochistic. And again, that's been the guidance for the court that ordinarily you need the person in there to take the oath, to take the testimony. But right, I mean, you are at that point hoping that the person being sworn in is not being fed additional information or anything like that. Now, again, it's unusual, and for the people watching this podcast who are perhaps more familiar with federal depositions. With federal depositions, once that deposition starts, if it's being taken by an opposing party, you're not anything you talk about. With some limited exceptions, such as whether or not to invoke a privilege, usually you're not going to have, there's not really attorney-client privileges to that. The opposing attorney can ask, would you and your lawyer talk about in that hallway? Under the Pennsylvania Rules of Civil Procedure, it's a little bit different. You can, were you to do it, and it would be obstreperous and ridiculous, but you could be taking breaks after every single question and conferring with the witness. Again, it's idiotic. And the party asking the questions.
In case any of my opponents are actually listening to this, I'm not suggesting that any of the attorneys involved would be doing this, but sometimes outside forces are brought in as like I said, like you don't want cue cards in the background.
But that's the point. The attorney isn't in the room either. The attorney is an officer of the court. The attorney is bound by rules of ethics, but just as there's no court reporter necessarily in the room with the witness, there's also likely not going to be an attorney in the room. And that's where, again, in certain circumstances, I've seen that pushback, because seasoned defense attorneys who are used to proceeding in a certain way and understandably used to proceeding in a certain way, they want to be prepping their witnesses in person. They want to be going over the documents with the witnesses in person. Some of that is lost when one is doing this via remote. There can be a lag in terms of objections, although, again, most objections are preserved unless it is a trial deposition. But getting back to what you said about the technology, that's quite another thing as well, to use the technology that interfaces with Zoom. Again, with video conference depositions, the technology is fairly well developed in terms of, hey, look, I want you to bring something up and show the witness X, Y, and Z and have them note on it. But you have plenty of attorneys that are not familiar or conversant with that technology and will struggle with that via remotely. And that's not their inexperience with the technology. They will generally understand not to be harmless for their client. And while one can certainly take CLEs, most deposition technology groups provide them to become more familiar with it, one really cannot fault somebody if they say in response to a demand they produce their client via video conference deposition. I understand you may want to do that, but I'm not going to allow that to go forward. We'll wait until we can actually conduct this with me in the room.
Yeah. And for me, one of the bigger issues, we have a fairly recently filed case involving a workplace accident. It happened in a facility that manufacturers, I don't want to say too much, but they make a consumable product, a food product. So getting engineers in to look at this machine is kind of off the table for this point in time. I mean, the facility is up and running, and they're considered, what's the governor's term, life sustaining. So it's not as though they're shut down anyway. They are running and operational. So that poses a significant problem for me. It's hard to defend a product that you can't, inspect.
Yeah, and even if the factory is up and running, unless you're using their in-house engineers to walk you through whatever relevant manufacturing process or design process, assuming you do want to bring in an outside consulting engineer, is that permissible currently under the rules? Don't know about that in terms of retained experts. And again, we'll even make this more basic. Corporate representative depositions require a corporate representative to be designated by the defendant. Again, these types of discussions, at least just through doing this work for more than a decade, usually involve round tabling by defendants to decide, okay, we're going to use Joe Blotz, given that these are the enumerated topic areas that the plaintiff wants to ask about. With COVID-19, that entire process gets more disorganized and as a result can gum up the works and slow things down. Again, these aren't problems that are insurmountable. Ultimately, we will find a way to make this easier and make this more expeditious. But currently, it's not only hard to demand it, it's hard to come up with an excellent justification as to why an attorney who's been doing this type of work for, say, 30, 35 years should upend it, barring an express directive from the Pennsylvania Supreme Court. Again, advisory opinions are great, and encouragement is great, but if you don't have really the backing of the court with a clear order saying you do X, the ways to escape from this or to delay it or to quasi-stay it are going to be there. And again, I always like to try to think about how I can word a letter so that I don't get a scathing response. But if the letter starts with, you produce your witness via video conference at this date, and that date is, with COVID-19 going on, again, you're going to get, hopefully, if you're lucky, a nice response along the lines of quo warranto. By what right are you requesting that?
I got one of those letters, and it was not to produce him via video. It was to produce him in person and to drag him from California. And my response was somewhat less cordial than that. And I double dog dare my opposition to attach that to a motion.
Right, and again, that just seems to me to be an unforced error. I mean, if you are going to be again, there are circumstances where, let's say, a corporate representative was already designated. It's going to be this guy or this gal. It's going to be on this date. It's going to be at this location. And then all of a sudden, COVID-19 comes out and the response is, I can't do it, and we won't even let you know when we're planning on reproducing this person. I think then you have a better ability to paper the record and demonstrate that, hey, wait a minute, okay, you're telling me that this person you already designated and presumably already prepped, you can't finish your prep via telephone and do that and be there in person. Now, again, the response can still be, yeah, I can do all those things, but I don't want to, and I don't think it's the best interest of my client. You, Oliver, have and I've faced it, and it was so good that I just basically had to surrender. You've demonstrated informed nonconvenience practices when the plaintiff says, hey, look, these witnesses Mr. Brooks is talking about, we can just have them via video conference at trial. And look, there are some judges that are going to be very receptive to that argument, but also there is the counter argument from the defense is, it's like, Your Honor, we're all big boys and big girls. If we produce somebody via video conference, the jury is just going to doze off, and this witness is important, and we want them there in person. There's merit to that argument. I don't think it always should succeed, especially when the witnesses will say, I don't remember anything about the accident or what have you. But we see other variants of that in terms of in-person is important. And that's just a hard position to assail if you're the one wanting the other side to produce their person.
Yeah. So how are you dealing with the defense firm that wants to do the in-person dep of your quad person? The finger?
No. First of all, never in writing in terms of that, and never. No, when somebody is taking a position like that, Oliver, and I imagine you have much the same reaction. It's like, that's a completely untenable position, and I want you to put it in writing. just so I can be very clear when I go to the court what you wanted to have occur. I mean,
Yeah.
this woman, because she is quadriplegic, is immunocompromised. And I would bet almost every dollar that I've ever made that I'm going to get a defense life care plan or life expectancy report saying this woman, due to her paralysis, is not likely to live a normal life expectancy.
Sure.
Okay. I mean, again, I don't agree with that, but I bet that's going to be taking the position, at least in terms of experts designated for trial. And yet, despite that, and despite the fact that this particular person is blameless, I mean, this person was just a passenger in a vehicle, and the driver of the vehicle has already been deposed, and all of the theoretical reasons that she could have caused the accident, like, for example, she yells at him or covers his eyes or, I don't know, grabs the steering wheel. Any theoretical way she could have caused the accident has already been completely ruled out. It's just, there's just absolutely no basis for that. So the entire purpose of the deposition is damages only. And by the way, these damages, because of the quadriplegia, are very specifically set out in the medical records. Why are we trying to have that person deposed in person without even expressing what the motivation might be for the defense? The insinuation enough is there. And I think any reasonable court would see that, say, let me get this straight. You want to depose this person in the middle of the COVID-19 in person. You've refused the overture of plaintiff to make that witness available via video conference deposition. And why exactly did you feel that was important? I mean, somebody does get called on the carpet for that, but that's not going to be as a result of me pulling my hair out, what's left of my hair, or screaming in a letter. I mean, just the position is just untenable. So yeah, the reaction to that is, okay, just so I understand your position clearly, put that in writing, okay? Put that in writing and send it to me, that this is what you want to do within this time period regarding this particular plaintiff who you know is a quadriplegic because you already have all of the records. So yeah, again, I don't, in cases involving, we'll say meritorious affirmative defenses of comparative fault, I could, in a vacuum, understand why a defense lawyer, and as far as I know, all defense lawyers do this, after they take a deposition of a party, they will typically write to the adjuster or write to the file about what their perception of that witness was. Are they going to make a good and compelling witness at trial? I can understand a defense lawyer feeling that that task is not going to be accomplished as comprehensively via video conference deposition than a in-person deposition. That's also why we videotape a lot of depositions, because the pregnant pauses, the the shifty eyes, all of those micro cues, some of them not very micro, some of them quite obvious, become a lot more understandable to the person in the room who ultimately has to advise a party as to what to do. Like, oh, we really got to be careful about this person. Or alternatively, look, I know what they told the police. I know what they said in interrogatories. Trust me, this person is going to implode at trial.
Yep.
I mean,
I had that just a few years ago where, you know, there was a very real question. Do we try this case? I mean, or do we come up with a significant amount of money? Because there's not a whole lot of in between on this. The damages are just too great. And I deposed the guy on video, and I was 100% try this to the just take him to the mat. The guy is a liar. He is scummy. You can just, there's an aroma in that room from him.
Right.
And everyone in my, I think 3 different attorneys on my team read the transcript and said, I just don't see it. And I made them watch the 6-hour deposition. They all came around.
Right. And again, which will not necessarily be borne out by any bare written transcript, but being in the room and seeing it, one is able to advise better. It's the same on the plaintiff's side with defense corporate witnesses.
It's quite a thing, you know?
Right. So again, I understand that when there are meritorious, substantive affirmative defenses on comparative fault, or if there, I mean, again, this particular one involving the quadriplegic, it's a vehicle crash, but it's a single vehicle crash. and it's a vehicle crash that does not involve a traffic light or a phantom vehicle that cut off or anything like that. So it's not that you are getting a different representation of the crash. Now, that might just be the rare circumstance, because oftentimes, particularly in products liability involving automotive defect, there's quite a lot about what the person says about the crash event, provided they didn't get a traumatic brain injury, that may become quite relevant. But yeah, one of these circumstances, when you have somebody that the defense is going to be claiming is severely immunocompromised, and they want to depose that person in person, what an awkward sentence. It's like, well, what, are you going to be passing her documents? Okay, are you going to? That's. I remember you and I sort of talked about this when it looked like when the NBA was ending its season. It's like, well, come on, with basketball, that's one of the most germ-spreading games there is, because everyone's touching the ball. They're all putting their hands all over it. And with courts, it's like, it's just as filthy. They're passing around papers, and they're just all packed in. We've seen what Discovery Court is. That is just a petri dish. So yeah.
I don't know if you mean that metaphorically or what.
Yeah, it is. Sorry, we have a young visitor who decided to take a stroll down the steps. He's now been sent back upstairs. He's wearing his pajamas, as most 4-year-olds are wont to do. But yeah, it was, I would think, here's the other thing though to think about in terms of demanding a certain type of discovery. Assuming your case is not like just about dead bang ready for trial, I can think of no other way to really enrage a judge who might be making other determinations in a case in terms of, hey, am I going to allow this type of discovery to go forward, or is this type of protective order something that I want to consider entering, than a party taking positions that, if called on in a crowded courtroom to defend itself, is going to have a lot of problems in terms of that. That to me, again, I use that phrase unforced error, but it just certainly seems to be. There are ways to be diplomatic about saying, hey, look, I don't think I can really properly represent my client by doing X, Y, and Z. And since the court has not ordered me to do this, I think we're going to wait and sort of see. Hopefully the country opens up in 2 weeks, blah, 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 as opposed to, your client is in a motorized recline wheelchair. She is quadriplegic. I want to depose her. I want to depose her in person in the next 3 weeks or whatever it may have been. That's just a hard sell. And even if you think you're in the right, that might be something to consider dialing back.
I actually just earlier today was on the phone with plaintiff's counsel, and I said, that particular plaintiff has some pretty significant mental issues that are not related to the accident. And she's really not, I don't think she's going to be competent to stand through a deposition. She's just not. I could be wrong on that, but I'm pretty certain that she's not ready or ever going to be ready for a deposition. However, I want to see what her injuries look like now, because it's been a significant period of time, and one of the allegations is that there's significant permanent scarring. So I just called him and I said, if I serve you with requests for production for photos, will you give me some photos? I understand you could probably take the position that you are not obligated to create evidence of any kind, but I think it's mutually beneficial for us both to know exactly what we're dealing with here.
It'd be a hard position for a plaintiff to take in a disfigurement case. It's like, yeah, my client is disfigured. No, I will not photograph her for you.
I think that technically doesn't have to go out and make photos for me, but it seems like kind of the reasonable way to handle this.
Ultimately, you'll be ending up in front of the judge, and if the response is, Your Honor, to my understanding, the plaintiff is putting forth a disfigurement case. Doesn't have to recreate the scarring or the disfigurement. I've asked for photos. His response is, I'm not going to give you any. And I don't want to, in this environment, be going to his client, breathing on his client, and being breathed on by his client and taking photos, or hiring a professional photographer to do that. Again, these type of tells, in an academic setting in law school, they might be very interesting, but I have to envision that most seasoned trial judges would hear, let me get this straight, Mr. Plaintiff Lawyer. You are pursuing disfigurement injuries. You are going to want to have that at trial. Are you planning a trial to perhaps blow up pictures of the scarring for the jury? Or are you going to tell me right now that you are not going to use that type of demonstrative photographic evidence? wow, that would really be fascinating. If you say, no, I'm actually not going to show them that. I'll just have her roll her pant leg up or pull her sleeve up in terms of that. I mean, obviously that's not realistic. So you're going to get the photos at some point anyway when the parties exchange their trial exhibits. So again, I think that if one were to say, hey, no, I'm not, as required to actually do that, I think that would be screaming volumes about the level of damages in that particular case. We have a case right now where a woman is burned over a third of her body. And the defense attorneys, they're good defense attorneys, they understood completely. It's like, look, we're not going to have her disrobe in the middle of the deposition. We trust you that you will hire a professional photographer and send us the photos. We have the photos immediately after the incident. We'd like the photos about 2 years out. And then when we have our own damage experts, when we do a defense medical examination, we'll just take pictures of her then. And it's like, okay, great, no problem. I mean, any type of resistance to that, again, is to me profoundly silly.
Yeah. So let's shift gears a little bit. You don't look sick. I look worse than you. I was going for the Gerard Butler in 300 look, and I'm more like the Kaczynski in 300 square feet look. So, when we go all over, I
don't know about that. I mean, we're talking about the Unabomber in terms of Kaczynski? Well, I mean, look, if one can have facial features, if we're dealing with bombers, between Ted Kaczynski and Richard Reed, the shoe bomber, one is probably doing okay, or at least not as bad as one could. The health is, it's been measured. It's been an interesting experience when one starts to present with certain symptoms. Thankfully, coming from a family of defense attorneys, we know a lot of doctors. I have a very good friend who pretty much runs the ICU of a local hospital, so that allows things to be expedited in terms of getting oneself evaluated. But also, I mean, I have not yet lost the perspective of I'm just a plaintiff's lawyer. I'm not a firefighter. I am not a surgeon, and I'm 41 years old. I'm not somebody that I feel comfortable of going in saying, "Test me, look at me, think about me." I mean, that's an unusual experience, but whatever I may have had, and maybe we'll get the testing results sometime. Eventually. I seem to be mending from whatever it
That's good.
was.
And I think the vast majority of people who are not, pre-existingly compromised are going to experience something similar to that, where you're going to feel like hell for quite a while, but you'll pull through.
You take that position, senor. There are way too many politicians and celebrities that have gone on and said things that then get disproven. All I can do is speak for myself. And as somebody who's got a 99-year-old grandmother who's now effectively in solitary confinement in her nursing home, she's not at this point in time been diagnosed with anything. I mean, it's terrifying. And I think that, I think you actually may have told me this one time, Oliver, and it stuck. It's like one of the things that's important to know and recognizing a good expert is when they admit that they don't know, that they admit that is not something that they feel comfortable answering, rather than the person who is basically the personification of a panacea. Oh, I can explain everything for you, and there's blah, 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 and I got an answer for everything. I got an excuse for everything and everything. What we're seeing with COVID-19 is that really nobody knows. I mean, nobody really has all of the information, and new information comes out every day, and one should be suspicious of individuals who claim to know or claim to have that information. We can already spot mistakes. We can already spot when there was ignorance or there was misrepresentation of then existing evidence. But in fact, watching this play out and seeing the various personalities, it almost now feels like a sitcom in terms of the people that come on every day for these press briefings. And I imagine you've probably talked to clients over the years about this, about how do we know we have a good expert? It's when obviously they're great on paper, they've got a great background, and they're thorough and they're careful, but also when they don't come across looking like an advocate. Okay, I mean, that's the attorney's job. The expert's job is to at least purportedly, dispassionately review the evidence, come to an independent conclusion, and if they're a defense expert, spot the mistakes, if any, with the plaintiff's experts' methodology or conclusions, etc. We have seen personalities, I won't name any in particular, that get in front of that lectern and say things, and you think to yourself, where did science end and whatever you are spewing began?
Well, I'll tell you exactly where it ended and where it began. It's right where the check cleared the bank. That's
what. It's a defense criminal attorney slogan, innocent until indigent, or something along those lines. But yeah, there are people now, and who knows 3 months from now what we might think of Dr. Fauci. But as of today, what is today? April 15th, is it? No, 14th, April 14th.
Man, you've been in the basement too long.
I did, in a bunker of sorts. April 14th, that's kind of an important day, but not as important as the 15th. But right now, viewing Dr. Fauci, one would think, boy, that would really be a good testifying expert. It's a person who's got a lot of expertise, who's measured, who can deal with questions, including some of them that may have bias behind them or hostility behind them, or be designed to rehabilitate somebody else. You see that and you think to yourself, at the end of the day, a jury would probably be very receptive to that type of a statement, even if we find, 14 days from now that he was totally wrong about X, Y, and Z. So yeah, it's curious to watch people like that, and then see the talking heads on the various television shows with their own experts, and they're all coming to different conclusions. And it's understandable that the viewing public would be, well, how are these well-credentialed doctors just getting it completely different in terms of the treatment and social distancing? Whereas you and I see that all the time in litigation.
And it's a tough position for him in particular, because if he is wrong and COVID-19 explodes and kills many more than it really ought to have, then he's a villain. If he is right and the measures are implemented but have significant economic ramifications, but we save a lot more people, that people will still say, well, you were wrong. Look, only this many died. You've been telling us the whole time.
It's a thankless position. But again, right now at least, the perception, at least from every poll that I've seen, is viewed that he is viewed favorably. But he is probably, I think he was a basketball player, but I'll just use a football analogy. At least from what I understand, being a swimmer, because I don't have a lot of eye-hand coordination. The best way to tell if you have a good offensive lineman is nobody ever talks about him, ever, because he's doing his job. He's not giving up sacks. When you're involved in, well, I guess we disbanded the pandemic response team, but if you're involved at the NIH, wherever it is, in terms of overseeing this type of stuff, the kudos you get is there's not a lot of mass death and mass panic. So yes, probably the type of job that doesn't get nearly the amount of thanks that it should. But again, just from a litigation perspective, as most of the audience, I guess, tuning in doesn't necessarily want to hear you and me wax on about politics, but watching people like that and getting an understanding as to how these people come across to a layperson audience. It is. I remember the first time I went to a trial and saw a medical expert testify. And you can read all the reports you want. You can look at voluminous CVs, and this person has presented 5,000 times and written 2,500 peer-reviewed articles. It is a different phenomenon to see somebody get up there on that witness stand and talk to a jury. It just is. And I think a lot of people are now, maybe for the first time, understanding how a medical expert talking just generally about a certain condition can come across. Most people's interactions with their doctor are limited to their own personal afflictions, maladies, diseases. In litigation, while there is obviously a plaintiff-specific medical testimony, oftentimes it will be a lot more elaborate and be talking about conditions in general, and why it is important for insurance carriers and defendant corporations to listen when people like you tell them, look, let me tell you about the retained experts they have, because I've seen them in a courtroom, and here's how they're going to come across. And yeah, you might think that they're totally full of it. It doesn't matter. They're persuasive, and ultimately, when they're in a trial, as long as they have a somewhat of a basis for their testimony, it is perhaps less about the medicine and more about the art of storytelling. And that can be hard. I'm sure the first time a doctor is sued and has to be briefed on, hey, look, I understand that you went to school for a long time, okay? And that medicine is complicated and medicine is not always predictable. You are not going to have a jury of your peers, okay? Not your peers. You're going to have a layperson jury. And you have to understand that while you may think you did everything right, they're going to have qualified people who say that you didn't. And it's oftentimes going to come down to other variables, not necessarily what somebody puts into a paper or what their experience was prior to testifying, but how they're coming across and how the jury is viewing them in the moment. I think that certainly applies to Fauci.
Yeah. So are you going to be out and about soon enough, or are you sticking in the basement till a certain date?
Are you inquiring as to whether or not I'm going to violate the current? It's not tower in place. Shelter kind of in place.
Yeah,
I will tell you that I will
in your yard and stuff.
Just because it's just between us
and
anybody who's watching. I've actually found, surprisingly enough, because I am one of those people, I'm kind of an old soul in that I like to touch all of the documents and sort of review them by hand and annotate. I thought it would be much more difficult than it has been, but I'm actually doing fairly well, Tom. The one issue that is not easy to overcome is to have 3 children, the eldest of which is 7, who are home. They don't have school and cannot, at least responsibly, be put to the side for the entirety of an attorney day, reviewing nothing but an iPad or a large television screen. There is something inherently problematic about them doing that. And you living in a close area to me, an area that's close to me, it has been rainy as of late, so they are indoors. That is kind of, that's become more of the issue in terms of that. It's just the normal everyday interruptions that one has. When this initially started, I thought to myself, okay, this is almost going to be like Sunday morning at the office, which is generally when I'm the most productive because my telephone is not ringing off the hook. I can kind of just bury myself in brief writing or in document review or in deposition preparation, and I can get a lot done. And sure enough, I could for the first 4 or 5 days. But then the reality of having little kids who are somewhat like their father, stubborn, perhaps a more accurate word would be relentless. They will take your attention from you whether you like it or not. So yeah, that has been thus far, perhaps blissfully so, the only real boy, I can't call it an impediment. Otherwise, I'm really going to be paying for a lot of therapy later on in life. But I will say the practical limitation on working at home.
Super fascinating episode about exactly what it's like having COVID. A lot of people talking about the law and the impact and business interruption, but what's it actually like having it? So interesting perspective. Thank you, Dan. Thank you, Oliver. Please make sure you like and subscribe to our podcast. We super appreciate the support. Until next time, catch us on The Defense Never Rests.